Impact of Influence, the Murdaugh family murders. This is the unfolding story of a powerful South Carolina family, the mysterious deaths they are linked to, and our quest to bring you the truth. Hello, friend. I'm Matt Harris, Seton Tucker here, of course, and we're always grateful that you decided to spend some time with us. You check out Impact of Influence on our Facebook page. Also, by the way, doing another podcast with Michael DeWitt called The Wicked South, and you can find that through wherever you get your favorite pods. Please rate the episode, share the episode, make sure you tell your friends, and we'd much appreciate that. So, we've got a few things that are new about the Murdaugh mess, and then we are also going to talk with an attorney in a little bit about some of the legal definitions, his theories on whether there or not there will be a new trial, what would happen if there is a new trial, how that will all work out, what the order of things would be. It's a pretty cool interview. Hopefully you'll hang around for that. And Seton, let's start with the biggest issue out of all of it right now is whether Alec will have a new trial. And it's all based on this idea that there was jury tampering by the Clerk of Court, Becky Hill.
Yes. So we have mentioned in a previous episode that the defense has filed for a new trial, and now we have received the state's response. And in their response, we have an affidavit from Clerk of Court Becky Hill. And in this, she says that she responds to these allegations, and that she says that I did not tell the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys. I did not instruct the jury to watch him closely. I did not instruct the jury to look at his actions. I did not instruct the jury to look at his movements. I did not say to the jury, this shouldn't take long. Then she says, when juror number 826 asked to speak with me, the conversation took place in the jury hall within earshot of bailiff Bill Polk, and the conversations did not involve the evidence, witnesses, or substantial or substance of the trial. And then she talks about an affidavit from Holly Miller discussing conversations with juror number 741. And she says, I did not have private conversations with juror 826 in the bathroom. My conversations with juror 826 did not involve evidence, witnesses, or substance of the trial. During the trial, I did not tell members of the jury that the media would want to interview them at the end of the trial. During the trial, I did not hand out business cards of the media personnel. I did not tell the juror, y'all are going to hear things that will throw you off, and don't let this mislead you. And then she responds to allegations that were presented in the affidavit then she responds to allegations that in the affidavit of juror number 785. It says, I did not tell the jurors to be fooled by the evidence presented by Alex Murdaugh's attorneys. I did not ask juror number 78. Then she responds to allegations that were in an affidavit by juror number 785, and a lot of the same things. But she also says that she did not tell juror 785 to forget about the guns, that they will never be seen again. She also says that I did not go in and ask for a raise of hands and that this would be done. And she did not tell juror number 785 that everyone needed to be on the same Facebook page. And says that she did not fabricate nor create any Facebook page related to juror number 785. And just to refresh our listeners' memories, juror 785 is the egg juror.
Which was the Facebook page that allegedly popped up, but we don't know. It definitely wasn't the ex-husband. At one time, there was a rumor of that,
and that was not why she was dismissed.
Not because of the Facebook.
It was
post.
about conversations she had with some tenants.
Yes. And so the Facebook page is really kind of a red herring in a way, because it didn't, according to Judge Newman, did not play into her being dismissed from the jury.
Right.
And the egg juror, we call her that because she had eggs she had to pick up when she was kicked off the jury. The general thinking is that she was maybe at least considered Alex Murdaugh not to be guilty. And that's why it becomes even more controversial because if you have the one Murdaugh person kicked off, then obviously Alex in a load of trouble.
Well, in the state's response, also, it says that they interviewed jury coordinator William Polk, and he says he did not hear any interference with judge, clerk, or any other persons in an attempt to influence jurors. So they've interviewed William Polk, jury coordinator, and they say that he backs up her claims. There's also this table in
Yes.
their motion, which was kind of interesting. What was your takeaway?
Well, they go through the different ones. Juror 193. She's heard Clerk Hill just say, "Pay attention." The other concerns, and Juror 193 says, "If anything, people were overly cautious." But Juror 254 said they heard Clerk Hill say, "Watch Murdaugh's body language." Juror 326, no, nothing about Clerk Hill's remarks. Juror 530, nothing about Clerk Hill's remarks. And then what other page? You have the other page there.
Jurors 578 declined to discuss the case or deliberations.
Just like,
just said, nope, not discussing it.
Yeah.
There was another juror who was not interviewed at the time of this filing. And of course, in this chart, because she was dismissed, we don't hear what the egg jurors' take was on any of these things.
589 said that their spouse was warned by her Putlian of a subpoena if they did not talk. 630 had been talked to. 729, just her general ideas about, she heard no body language comments.
Well, I guess the juror who was threatened to be subpoenaed by her Putlian maybe did not take kindly to her Putlian showing up at their doorstep.
Right. Well, and 729 said that about the trial was uncomfortable when Harpootlian waved the gun around. And juror 864 said it was Creighton Waters in court who told the jury to watch her body language, not Becky Hill.
I do think I remember Creighton Waters saying that. So,
yeah. I think that's possible. Maybe they got confused where it was. It still remains to be seen how this will all play out. But this is the first time, of course, we've heard from Becky Hill because she's not going to speak unless it's under some sort of legal thing. She's not going to go talking to a newspaper or something about this. So this is the first time we hear from her and her total denials of every single one of the charges.
Right. So she responded in the appropriate way by filing this affidavit and saying, all right, this is my take, not, giving interviews and that sort of thing.
What do you want to hit next here?
Well, let's talk about Corey Fleming's sentence. ABC News 4, Drew Tripp and Ann Emerson interviewed Charlie Condon, who's a former attorney general, about what his take was on the possibility that Corey could get a new reduced sentence.
So to remind you, he was on September 14th, pled guilty to 23 fraud money laundering charges involving the Hakeem Pinckney story and the Gloria Satterfield story. And South Carolina Department of Corrections said his release would be the earliest in October of 2032. Parole not until March of 2032. Now that's just the state,
because some of the, I think with the money laundering charges, he was required to serve 85% of his time.
Right.
So that would be 8.5 years. They are running, his federal charges are running concurrently with the state charges. But he's going to have to spend at least a portion of the time if these charges stick in state prison.
And the federal sentence, basically, just to make it less confusing, only set to serve 3 years, 3 months.
Well, not charges. I mean, the sentence.
Sentencing, yes. Yeah. So he'll immediately transfer from federal to state after he does his federal first. That's the way it's going to be. So, so they appealed, saying that Judge Newman was too hard on him. Despite the client's admission of guilt, he was excessive and unfair to Corey Fleming, and that he was biased, and they talked about a cruel and unusual punishment. And then, so what you're talking about is the statement by Charlie Condon, former South Carolina Attorney General, who said that why didn't the Fleming's lawyers raise these objections during Fleming's sentencing hearing? Why they didn't file a motion for reconsideration with Judge Newman before taking their case to the appeals court? Fleming's sentence could have been higher. Could have been much
A lot
higher.
of people have put that out there, but then also there have been arguments that he received a much stiffer sentence than other lawyers who've done similar
things in
things.
South Carolina. Yeah, so Condon saying, well, I mean, I guess the argument with Condon would be, I would assume his Fleming's lawyers would say, well, we couldn't brazen it because we didn't know what it was going to be.
Well, Condon seems to think it's unlikely that Corey Fleming will receive a reduction in his sentence. I tend to think he's right.
As far as we know, as for the legal, I can't imagine.
We don't know. We're not legal.
But it just seems weird, though, right? That they would
you can't just go. It seems like you can't go back and say, "Wait a second, I pled guilty, and now I don't like this sentence, so give me less time."
Yeah. So that is that. Next up, let's see. Do we have another one?
Yeah, just a quick. We did have there. People had to file their claims against Alex Murdaugh's estate. And, lots of victims we've heard about, Satterfields and, all of the victims of Alex financial crimes. But we also have claims that have been filed by PMPD, or now, what are they called now?
They have a new name now because
the Parker Law Firm or something. And then also by Randy Murdaugh. And there was a lot of public outcry about this. People thought, it was obviously it could be Pinckney, people who've been stolen money, maybe his brother and his former law firm shouldn't get in line. I don't know what the right answer is, but there was a lot of public outcry.
I guess it depends on where they are in the line too, right? Like maybe nothing will ever get to them.
Well, at the beginning, there was a lot of talk that Randy was attempting to kind of jump in front of other people because
I remember that little story.
He quickly filed that his brother had owed him money.
Right.
And I think in reading his claim, he paid for some of the rehab and all these things, but
I just don't know where all the money's going to come from anyway at this point. It seems like it's dwindled a little bit.
How much is there left?
Right. Because they've paid.
Is it even worth? Is it worth getting in line?
Yeah, I don't know. We'll dig into it at some point.
Yep.
Ready for the guest?
Yep.
Great interview. So hang in here. Now we move on to our guest. Joining us is John L. Warren III, an attorney with the Law Office of Bill Nettles. Previously, John clerked for judges in the Supreme Court of South Carolina, Federal District Court, and Fourth Circuit Court of Appeals. John's practice now focuses on whistleblower litigation, criminal defense, capital litigation, and appellate litigation. John, welcome to the program.
It's good to be here.
Well, John, we were talking last week. There's so much legal wrangling and terms that are going around that want to help our listeners understand. So let's kind of start off with what is a writ of prohibition and how often is this used?
Sure. So generally a writ of prohibition it's a means by which a court can prevent a lower court from doing something. So the South Carolina Constitution vests the Supreme Court with the authority to issue writs of prohibition. And essentially what that is it's just an order from the Supreme Court telling a lower court or another government official not to do something. So rather than coming in and fixing an error after the fact, it allows the Supreme Court to stop something before it may become an error.
So explain what the writ of prohibition, what it means in this specific Murdaugh case.
Sure. So the writ of prohibition here is a request for the Supreme Court to prevent Judge Newman from presiding over any of the matters related to Murdaugh, whether that's the motion for a new trial, the financial matters. They're asking the Supreme Court to prevent or stop Judge Newman from presiding over any of those matters.
And the reason they did that is to what? To prevent a backup on getting this case through quickly?
So I think, and this is just a little bit of reading the tea leaves, because only his legal team knows why they took that approach. I think the most likely answer is typically when you ask to recuse a judge, which is not something that's altogether very common in general, but when you ask to recuse a judge, you first file a motion with that judge. What's a little bit unusual is in South Carolina, if they were to go ask Judge Newman, file a motion with Judge Newman asking him to recuse himself, and he denied that motion, there would not be a way for them to appeal that ruling. So they would have to actually go through and litigate the motion for a new trial before being able to appeal the question of whether Judge Newman should recuse himself. Filing it as a writ of prohibition with the Supreme Court allows them to skip that and get it into an appellate court, where I suspect they think they have a better chance of prevailing without having to litigate the entire issue.
Okay, so we have a lot of pending litigation. We have this writ of prohibition that we just discussed. We also have the defense announcing their intentions to file an appeal with the Supreme Court. Now, this has been stayed until they sort out these jury tampering allegations. There is a motion for a new trial. There's also the talk about this evidentiary hearing to take place about the jury tampering. And we have financial crime hearings with Alex Murdaugh scheduled for the week after Thanksgiving. What's the order? How will this all proceed?
Yeah, I think that's unclear. I think that the common denominator to pretty much all of those is Judge Newman. And so I think that first, the question of which judge is going to preside over those matters is going to have to be decided. The Supreme Court could decide it. They could rule on the petition for a writ of prohibition. They could also decline to make a decision and send it back, in which case I suspect Dick and Jim would then ask Judge Newman to recuse himself. As a practical matter, I think it would be very hard for any of the matters, whether it's the motion for a new trial, evidentiary hearing, or the financial crimes. It's going to be really difficult for those to go forward with pending litigation about whether the currently presiding judge should still preside over those matters. So I think one way or the other, we'll get some sort of decision on the recusal request.
You've been involved with the law in South Carolina for a long time. Have you seen this situation before where a judge was asked to step down and people went to the Supreme Court to ask him to make that decision?
I have not personally seen that.
Yeah. So it's pretty rare, obviously.
It is. I mean, writs of prohibition in general are very rare. The South Carolina Constitution allows people to seek those from the Supreme Court. It's extremely rare. The writ of prohibition is called an extraordinary writ, and it's called that because it's an extraordinary remedy that the Supreme Court doesn't issue often. And really, the last petition for a writ of prohibition that was issued, at least as far as I know, was when the Supreme Court issued a writ of prohibition on the Gerard Price matter. And that was actually a writ of prohibition that was filed by the Attorney General's office. That was the case where Gerard Price was released early from prison by Judge Manning. Attorney General's office filed a petition, and the Supreme Court actually granted that relief. So until recently with that case, it's been quite a while since a writ of prohibition's been granted.
That's pretty interesting because that happened I guess, Gerard Price was 2 months ago when that all went down. So that this has happened twice in a very short period of time is pretty interesting.
And it was the other side, right? So it was the state
Yes.
that filed the writ in that case, right?
That's right. And it's not infrequent for there to be attempts for a writ of prohibition to be issued by the court. It just typically doesn't happen. So I think it is back in September, the court did issue the writ that the Attorney General's office requested. So I think in kind of an odd way, the Attorney General's office, in seeking the writ in that case, has kind of revived the writ of prohibition in South Carolina.
It's fresh on their minds, right? Yeah.
Well, okay, so we have these financial crime hearing that's supposed to take place after Thanksgiving, but we also forgot to mention that we have these federal court. Alex Murdaugh has pled guilty, and we're waiting for sentencing on that. And so Dick Harpootlian has said they want to delay this financial crime hearing. So there's always that question of whether they want him to get sentenced federally first before because if you get convicted in state court, you get sentenced right away. But in federal court, there's some time between getting convicted or pleading guilty and getting sentenced. And so, there's
That's
always
right.
the question of whether this is an attempt for Alex Murdaugh to try to get to federal prison.
So you're exactly right that there is a gap in federal court. The United States Probation Office prepares a report. The parties have a chance to object to it. And it's not uncommon for a sentencing to happen 3 to 5 months after a guilty plea. In terms of where he will go to prison, when you've got parallel state and federal proceedings, it's a complicated issue of where someone will actually serve their time. Generally, the rule is that the state or the federal government, so the sovereign, that has primary custody over a defendant, that defendant will go to that prison. So with all of this pending and Murdaugh having a bunch of pending financial charges and a murder conviction and sentence, even if he were to get sentenced on federal charges tomorrow, that's not going to change the fact that he would go to the Department of Corrections.
So he's still going to stay in state prison, most likely.
He's still going to stay in state prison. In my opinion, I think the only way that would change is if, for example, he were to be granted a new trial on the murder charges, and the court set a bond that he was able to make. So if he were to get released on bond on the state charges and then be sentenced on the federal charges, then he would likely go to the Federal Bureau of Prisons. A lot of chess pieces have to fall into place for that to happen.
Plus, the odds of him getting bond have got to be pretty slim.
Initially, when he was, there were only before the murder charges, and what was the bond set at? I can't remember what it was. It was
ridiculous.
We couldn't make it.
It was super high.
He could not make it then.
Yeah.
That's right. It was several $1 million, and I think, and the other issue too is in federal courts. I think that his sentence is likely to be. I don't know what his guideline range will come in, but it'll be high, but it's not going to be the rest of his life.
Now, if Alex Murdaugh does happen to be granted a new trial for the murder charges, where will that trial happen? Will it be back in Colleton County?
It's a good question. It really depends. So the defendant Murdaugh could file a motion to change venue. The Supreme Court, in ruling on this writ of prohibition, could assign the matter to a judge outside of Colleton County. The statutes on where state grand jury cases are tried are kind of complex, but it's really up in the air. There will be, if there's a motion for a new trial granted, I feel quite certain there will be litigation on that question of where the trial will be held.
So basically everything starts from scratch. Nothing remains. So it's just the new trial means a new trial. Nothing is out of play. So they just start from scratch where they decide change a venue or not. They do juries, just everything as if the other thing never happened.
Yes and no. So in terms of the actual trial, yes, they would start over from scratch. It'd be a new jury picked. there would be a new trial. What complicates it, and there's not really a clear answer to, is Alex Murdaugh testified in his first trial. Depending on how a new trial played out, there could be situations where that testimony from the first trial could be introduced, likely by the state, in the second trial.
What about the financial crimes? I mean, so the financial crimes were admitted in the first trial because they said that Jim Griffin opened the door in some of his questioning of a witness. Would that necessarily be included, or automatically it starts over?
I think that again, it depends. So assuming there's a new judge, that judge could have a different view of what evidence comes in other words, what kind of evidence about the financial crimes comes in the murder trial. That said, obviously Alex Murdaugh's testimony focused in large part on the financial crimes. I think there's again going to be a litigation on that issue. I would say if there's a new trial granted, that's going to be one of the most hotly contested issues, because the state is going to say that Murdaugh provided lengthy testimony about this financial crime evidence, and the defense lawyers are going to say that the reason he did that is because the judge allowed the state to introduce that evidence. So it's a very unclear question. It could get very complicated.
Yeah, it's a chicken egg kind of thing. He had to do it because you did that, but you shouldn't have done that. And so, yeah, that whole setup will be very interesting. So if there was a new trial, are they allowed to change witness list? Are they allowed to present a whole different? I mean, granted, I know motive isn't. You don't need motive, but could they change their technique or their whys and hows and everything?
Sure, no, absolutely. Sometimes you get, I would say, the most common scenario where a new trial is had is when there's a hung jury in a case. So, say the state or the federal government tries a defendant for a crime, jury can't reach a unanimous verdict, and the state or the federal government has a second trial. So in that case, it's not at all uncommon for the state or the federal government to piece together new evidence, to come up with new witnesses. That's not at all uncommon. I mean, both parties, both the defense and the state, will spend a long time reading the transcripts from the first trial, trying to figure out what they may have done wrong, trying to figure out what the other side may have done wrong, and trying a case the second time is a difficult endeavor, because everybody has an opportunity to really reflect and adapt.
It's a redo for both. It's a redo for both sides. Can see what they thought worked and what they thought did not work.
So is discovery all new too?
That's right.
Is discovery all new? Like what?
So, in terms of the process of discovery, I don't think that everyone would have to start from scratch in terms of reproducing discovery that has already been produced.
Okay.
That said, the state and to an extent the defendant, but really the state, has an ongoing duty to produce discovery, particularly certain types of discovery that go to the defendant's guilt or innocence. So if there is new evidence or new witness testimony or interviews by law enforcement that come up between the first trial and the second trial, that would certainly have to be produced by the state.
So, okay.
Can I dig? I want to dig a little deep into the woods for a sec, or into the weeds or the woods. You probably, let me just lay it out there and we'll see if we can answer it or not. So one of the things that came up was that it was presented to the grand jury in a certain way about this evidence of
bloody shirt, the bloody shirt,
spatter or whatever on the shirt. And they said, the defense argued that should never even have gone to the grand jury. But that ship has sailed, right? So, I mean, we can't go back and go, we're starting with grand jury level, right? I mean, you can't start there, or can you?
Again, it's kind of a little bit of uncharted water. So the state can generally always go back to the grand jury when a case is pending. So let's say someone's been indicted, the state can go back and get what we call a superseding indictment. Yeah, I think that the evidentiary issues related to things like the bloody shirt can be relitigated in the second trial. I mean, everything's kind of fair game, but I don't think that everyone's going to have to go back to square one in terms of. I mean, obviously, what's happened has happened in the investigation.
You're not going to re-indict him. You're not going to have to do the re-indictment.
I think that would be unlikely.
Yeah.
Well, what would be interesting is if, again, this is just all guessing on all of our parts. If there was a new trial, you could get a new trial based on these jury tampering allegations, or a new trial based on potentially the entering of the financial crimes. So there on appeal. So there could be different. Oh, that's a motion for new trial. The other one would be an appeal. So I guess I'm still just curious about these financial crimes, like what's going to happen with them, because that seems to be, to me, the most hotly contested thing
on the appeal process.
Yeah, I think I think that's right, and I think that whatever judge is assigned, whether it's Judge Newman or another judge, particularly if it's another judge, is whether knowingly or just kind of unknowingly, I think the weight of the appellate issues about the financial crimes may affect their decision on whether to grant a new trial. If you have a new judge come in, it's evaluating this motion for a new trial, and it's a close call, that judge may take into consideration the likelihood or the possibility of an appeal being granted. Because if the motion for new trial is denied, then the case goes back to the South Carolina Court of Appeals, or the Supreme Court, if they took the case, could also grant a new trial just on evidentiary grounds. So, a new trial really does kind of reset the clock on all of those appellate issues that are currently stayed in the South Carolina Court of Appeals.
Will the whole country, from a legal perspective, be watching this?
Based on my experiences in the first trial, I think it's very likely. And that was one of the only times in my life where you could travel to New England or Denver and get into an Uber, and the Uber driver know more about what's going on in a South Carolina trial than I did.
And there's a lot of lawyers lawyering. So
it's
case
a
law.
lot of armchair lawyers. That's right.
Yeah. Thanks so much. I really appreciate you joining us. You really broke it down perfectly for us. So we'll have you back at some point.
Yeah, thank you so much for coming on. We appreciate it.
Thanks for having me.
Thank you. Bye.